2016, he urged the court that in passing sentence of the period the accused person had been in custody to be considered. He went to submit that though the accused person is a first offender, the court should mete out a very serious custodial sentence, bearing in mind that the offenses are very serious and that they attract very serious penalties. He invited the court to consider the impact of the offense that the offense has had on the victims, the general intelligence of the accused person, and the fact that the accused person has shown no remorse and the defenseless nature of the victims. He proposed the maximum sentence on each count, less the 8 years the accused person has spent in custody pending trial. He further submitted that the accused person be ordered to serve the sentences consecutively. In mitigation, Mr. Chacha for the accused person submitted that the accused person is very remorseful. He conceded to the fact that the charges that the accused person has been convicted of are quite serious in nature, and submitting further, he stated that there has been recent jurisprudence in sentencing and that the court has discretion in sentencing, urging the court to be lenient to the accused person. Regarding the behavior of the accused person pending trial, the court was told that the accused person has been of good behavior while in custody and that the court had not received any complaints from prison while the accused person has been held. He distinguished this case with other terrorist cases, stating that this case has had no direct victims, unlike other cases where the aftermath is death and bloodshed. He argued that the maximum sentence prayed for by the prosecution cannot apply since the accused person is a first offender. Further, that the accused person is a young adult who during his stay in custody has come to terms with his life, and that he deserves a second chance, considering that he's a young man who had just gotten married to the second accused person. That the 8 years he has been in custody have served the purpose of retribution, and that it's also be a deterrent, and the accused person has been rehabilitated. The court was further informed that the accused person has met officers from the National Counterterrorism Center and that he has denounced all his earlier associations. That the objectives of sentencing having been met, the defense urged the court to consider a non-custodial sentence of up to 3 years supervised by the NCTC and the probation department, and that in case of violation, the case will have the liberty to recommend a custodial sentence. The court was urged to consider a concurrent sentence since all the charges boil down to a series of events from one action and that the evidence is very similar. I have considered the submissions by the prosecution and the mitigation by the accused person. Both sides do concede that to the fact that the accused person is a first offender. It is also conceded to by parties that the offenses with which the accused person has been convicted of are serious in nature, and that the sentences provided for under the Act are also serious. The court has considered the nature of the offense and the manner in which the offense was committed. The court finds that 1, the offenses consisted of mainly of a collection of information as opposed to collection of weapons. 2, that there was no injury, bloodshed, or death that occurred as a result of the offenses. And 3, the accused has shown remorse and willingness to reform. It was submitted that the accused person has held several meetings with officers from NCTC and that he has denounced all his previous association. This fact was not rebutted by the prosecution. The court has also noted that the accused person is a young man who had a budding medical career and was recently married prior to his arrest, and he has pleaded to be given a second chance in life, and further that the accused person is a first offender who has maintained good behavior while in remand, pending or awaiting trial. In the case of Republic versus Mancha, it was held that a person convicted of a terrorist offense must expect substantial sentence to serve as a deterrent to others and mark the extreme seriousness of criminality. In that case, a sentence of 6 years imprisonment was imposed. Owing to the serious nature of the offense and having considered the accused in mitigation, I find that a non-custodial sentence as proposed by the defense is not appropriate in the circumstances. However, The court has been urged to treat the accused person with mercy, and considering the factors that have been outlined before, on count 1, the accused person is sentenced to serve 12 years imprisonment. Count 3, the accused person will serve 12 years imprisonment. Count 4, the accused person will serve 12 years imprisonment. 7, 12 years imprisonment. And count number 8, accused person will serve 12 years imprisonment. Having noted that the offences were committed in a series of similar events and that the evidence cuts across the same period and time, I find that the sentence should run concurrently. Time shall start running from the date of arrest. Right of appeal in 14 days. In respect of count this accused number A2, 3, and 4 will be, yes, it's all right. Was the passport deposited as a security, not as an exhibit? Okay, it was a security as such. Thank you. Mr. Andy, number 1560 of 2020, miscellaneous application 1560 of 2020. With the file, if I could deliver the ruling, it will be uploaded, and with an